Good evening, I'm Steve Rose. Welcome back to another episode of Lawyer Lens. In light of the leak, so to speak, of that up-and-coming Supreme Court decision that could have ramifications, perhaps huge ramifications on Roe versus Wade, I thought I'd take this opportunity to make a video about abortion, but in particular, less so with regard to whether or not what's correct or what I'd argue, pro-choice, pro-life, etc. I really like this just to take this opportunity to really discuss why men should be a part of the conversation, should be a big part of the conversation. I am a strong believer in inclusivity, and I feel that too often in today's society, inclusivity is too often defined by physical characteristics. It's defined by identity, really, but it should also include, if anything, thought. We should be inclusive of thought. We should welcome diversity of thought. It helps us learn. It helps us grow. Without diversity of thought, we're just in our own echo chambers, and we just, I guess our ego is happy because in our minds it reaffirms how right we are, but in reality, we should welcome diversity of thought. We should learn how to have adult conversations with each other. And guess what? Just because somebody disagrees with you, it doesn't mean they're insensitive. It doesn't mean they're hateful. It just means that they disagree. I mean, some people are hateful and insensitive, sure, but too often people today are just shutting out opinions that they disagree with, and they're incapable of even having a back and forth or a conversation. Not every disagreement has to be a fight. And I believe we need inclusivity in all important issues, including the real important issue of abortion. Now, one could argue a fundamental point that's brought up quite often, well, you're a man, so I don't want to hear it. It's my body, my choice. And I just want to flat out say, while I have certainly empathy for the differing position of women who actually carry babies, and I feel like a lot of men lack such empathy, sure, but at the same time, I believe that you can have such empathy while at the same time saying, no, men should absolutely, it's too important of a conversation for men not to be a part of. And as I will show in this video, if you believe in pro-choice, if you vehemently believe in the language in Roe versus Wade, well, that language, that analysis, and even the analysis of pro-choicers, according to the latest polls, if you flesh that out, that analysis will actually tell you that men have to be a part of the conversation, that it's not about a woman's body all the time, and it's not simply about my body, my choice. So you have a Supreme Court decision coming up. It's not important to get in too deep into that because we haven't really seen the decision. We have leaks, we have what may be an opinion, but let's lay some background first. What are we talking about here with regard to Roe versus Wade, and why would Roe versus Wade, or whether you're pro-choice or pro-life, why would any of that lend to an argument that men should be included in the conversation with regard to abortion? Roe versus Wade is a case that, so you have 1973, Norma McCorry, a woman in Texas, she was in her 20s at the time. Norma wanted to get an abortion. At the time, the law in Texas said flat out, under no circumstance are you allowed to get an abortion unless the woman's life is in danger, a danger to her life or her health. Ms. McCorry sued the district attorney in her county in Texas. His name was Henry Wade, because the district attorney is charged with the enforcement of the law. So she sued him, but she didn't sue him under her own real name because there could be dangers involved. So she used a common vehicle in court. There are some men sometimes sue or are sued as John Doe. She sued as Jane Roe. So it was Jane Roe versus Henry Wade, i.e. Roe versus Wade. And she sued in district court claiming that the statute banning abortions unless the women's health was seriously at issue, unconstitutional. So in the federal court, on the federal level, you have three levels. You have a district court, which is the first court. You have, after the district court, you have the appellate courts, you have the appellate circuits. You have circuits all around the country depending upon the geographical region. And then you have the Supreme Court. Sometimes, though, you can go directly to the Supreme Court, or you can go from the district court to the Supreme Court, as we'll see is what occurred in this case. So the district court heard the case, considered the Texas statute, and said that the statute was unconstitutional, that it was unduly vague. The district court brought up the 9th Amendment, which basically says any right that's not specifically enumerated in the Constitution belongs to the people. This is a fundamental right. It belongs to a woman. A woman has the right to choose what she does with her own body, in the case of abortion as well. But the district court, while it seemed to say a lot that was in line with Ms. Roe's argument, they did not put forth an injunction against this law. i.e., as a result, after the district court's decision, the Texas statute was still in effect. So in essence, Norma did not have the relief that she wanted. So as a result, she appealed and she was able to go right to the Supreme Court. So you have a Supreme Court case. The citation, if anybody wants to read, it's free online. It's a fascinating read because I feel too often people discuss things based on blips on the news or their favorite sources, and they have a scant idea of what it is. It's always good in these topics. It makes for more interesting conversation, and it's interesting to know to go to the source and read the case. You don't have to be a lawyer to understand this case. I mean, a lawyer is going to get some intricacies in language that a layperson might not get, but a layperson can surely read most Supreme Courts and understand exactly what's going on in most cases, and can do so with Roe versus Wade. The citation 410 Sorry, I may be a lawyer, but I write like a doctor sometimes. 410 U.S. 113 Roe v. Wade. That's the citation of the Supreme Court decision. It can be looked up. You can Google that citation, or you can simply Google Roe versus Wade. It's a popular case, and I'm sure it can be found out that way. With regard to Roe versus Wade, the Supreme Court struck down the Texas statute as unconstitutional. The Supreme Court said it was unconstitutional under the 9th Amendment, but in particular under the 14th Amendment right to privacy. The Supreme Court considered this a privacy issue for women, that women have a fundamental right under the Constitution of the United States to make that personal private decision. There was a case that preceded this called, it's referred to as the Griswold case, and the Griswold case talked about privacy, and basically the Supreme Court extended the right of privacy from that case in a different area to a woman's right to choose whether or not to get an abortion. And with regard to that right of privacy, the court did not stop there. If the court stopped there, then the court would simply be saying a woman's body, a woman's choice. But the court did not stop there. The court issued a test, a balance test, a state's compelling interest versus a woman's right to privacy. If you understand the history of Supreme Court decisions and how it works via the different areas and clauses of the Constitution, by the Equal Protection Clause, the court will often use in its decisions a state compelling interest test. States have compelling interests in order to run a just society, a stable society. There is an interest, for example, in maintaining the public health. That's why many argue that the state has the right to enforce certain provisions with regard to vaccinations in the past, and certainly it was brought up in the present, etc. You have states' compelling interest to police, and for another example, there are certain compelling interests of the state. A state compelling interest brought up in Roe versus Wade is with regard to the life and viability of the fetus. Okay, so what the Supreme Court did was they made it a term test. So basically, where is it that the state's right to protect a fundamental interest, which is a right of life, where does that begin, and where does that perhaps outweigh on the scale a woman's right to privacy? So you have the courts, the justice that delivered the opinion was Justice Blackmun, and basically they made a 3-term test. So you have the first trimester, first try, basically up to 24 weeks, and then you have the second try, and then the third trimester. Basically, late term, i.e. full viability under the science then. The science now might suggest that viability could come earlier than expected, but the bottom line was the Supreme Court set up a term test, so to speak. So basically, within the first trimester, the Supreme Court said, under no circumstances can a state put forth any rules whatsoever that would restrict an abortion. I mean, there are certain minor things that a state can do, like, for example, a state can say that, well, if you're going to get an abortion, it has to be by somebody who's a licensed healthcare professional. You know, various things that protect basic health and public safety standards. But the bottom line, as for this discussion, is in the first trimester, the woman's right to privacy outweighs a state's compelling interest to protect life. So, no restrictions. Second trimester, still under the science of that time, not considered full viability. Maybe there is some survivability, but it was not looked at the time as a fully viable fetus that can come out and exist, you know, and live without special intensive care available at the time. So basically what was said here was the state can impose some restrictions, but they have to be based on protection of the life of the mother. So really highly limited restrictions. Okay? Third trimester, where the fetus is viable and much more developed, and of course, well more than the first trimester. The Supreme Court said a state's state's compelling interest outweighs a woman's right to privacy, and a state can absolutely ban abortion in the third trimester. Can ban abortion. The only exception being if the woman is going to, if there's a huge threat to her life or health, then abortion would be allowed. But we'll go into the reasons for abortion in a little bit. But basically, under the predominant reason of why people get abortions, in the third trimester, the state can absolutely ban abortion. So you have the 3-try test. Now, going back to the argument, well, my body, my choice. Well, if it were that simple, then you simply do not believe in Roe versus Wade, because a fetus is just as much in a woman's body in the first trimester as the fetus is in the third trimester. The fetus is in the woman's body in the third trimester, so if it's my body, my choice, then under that argument, if you're going to stick to that, then you would have to say that a state cannot ban abortion in the third trimester either, and thus it could be full term. You could still get an abortion as long as the baby's inside you, because my body is my choice. You can argue that, you can believe that, and people can differ and disagree, but the fact of the matter is that is not in line with Roe versus Wade. Roe versus Wade highlights a difference, and the difference is obvious by its decision. Now, if you look at this, what is the difference here between the first and third? If you look at the decision, it's time. What comes with time? With time comes the development of the fetus, and that is it. And there are new questions from then. So the question is, at what point does a fetus acquire the right to a life? At what point does life begin? When does a fetus feel pain? When does the fetus develop fully functioning organs, develop extremities? How developed is the nervous system? When can, at a certain point, when can the fetus feel real pain? What are we talking about here with regard to what happens over time? All of these questions, when does life begin, the development of the fetus, they are scientific and moral in nature. As a result, this is a conversation that anybody can have. This is a conversation that not only men can contribute to, but you would want men to contribute. You don't want to shut down almost half of the society from such an important question. This has to be discussed by everybody. It has to be fleshed out because the stakes are high. This is very important. We have two competing, extremely important interests here. We have a woman who's struggling, who's going through a monumental decision. We have health care involvement. We have all kinds of people involved. We have a fetus, and we have to determine what is the ethical and moral thing to do with that and with that fetus. And we have to answer all of these questions. And because, as outlined by Roe versus Wade, it's not only a question of where the fetus is located, but how developed the fetus is in putting forth when the state compelling interest can come in. In light of that, it's not as simple as my body, my choice. Now, it doesn't mean my body, my choice can never be said. In fact, I would take out my body, my choice, and I would just put my body, so that we don't forget that, yes, it is a woman's body, and we have to have empathy when we're talking about that. And, you know, a man has to realize that they're not going through what the woman is going through, and take that frame of mind to a conversation. Sure, always appreciate where somebody else is coming from, but at the same time, absolutely, if there's any area, it's an important area like this where you want as much diversity of thought as possible. You want that as informed a decision as possible. And By the way, so with regard to this decision, just to give a frame of reference as to where each side belongs. So basically you had the more left-leaning liberal side of the court discussing this as a fundamental right and a constitutional right, and then putting forth an equal opportunity clause kind of test where you have states' compelling interest versus a fundamental right, etc. So basically the left is saying this is a constitutional right and it's a fundamental right. The right, like for example, you had Judge Rehnquist, you had Justice White, if I remember correctly, dissenting, and basically what the dissent says is this is not in the Constitution. It was basically made up, and because it was made up, we essentially have an oligarchy here. We have 5 lawyers in black robes making a decision for society. In a representative republic, it's the representatives, i.e. the legislatures, both on the state level and the federal level, that should be making this decision, and not 5 justices in robes. Justice Rehnquist went on to argue that this is clearly not a fundamental right, as most states at the time had bans on abortion. I would push back on that and say that's not by itself necessarily indicative of what is a fundamental right. I mean, remember, for example, there was a time, I'm not comparing the two issues, but just to lend to the conversation, there was a time when a great deal of the states thought that the right to own slaves should exist too. You actually had a court decision actually agreeing with that. But my point is, just because most state legislatures believe something is right, it doesn't mean that they're not going against the fundamental right. Even 90% of the state legislatures can all agree on something and still violate the Constitution. Now, they can decide if they have the votes and wherewithal to amend the Constitution. That's one thing. But what I'm saying is, just because most of the states felt a certain way at the time, it doesn't mean that what they were doing was not unconstitutional. It could be either way. Like I said, the thrust here is not really to argue one side or the other. I'm just presenting both sides and what they were saying. One side, abortion is a fundamental right, and over time, that right has to be weighed with the state's compelling interest to the health of the fetus. And then you have the other argument saying there is no constitutional right. The justices can only interpret the laws that are on the books. They should not be making up laws out of thin air that will essentially take away from the representative republic. Roe versus Wade is not the only thing that demonstrates the importance and really the logic behind that men should be a part of this conversation. The discussion about abortion today even lends to that, even if you are vehemently pro-choice. Speaking of today, just to talk about a little, to bring abortion into context and what we're talking about here. Too often with regard to this debate, not only do we shut off half of the society by saying you're a man so you can't discuss it, which goes against the logic in Roe versus Wade. Too often you also have, well, what if a woman is, like, right away, like sort of a knee-jerk like reaction? Well, what if a woman is raped? What, you think that a rapist should be able to keep a baby, and the woman should have to use her body to have the baby? Or what if the woman's life is in danger? That's not the conversation, because if you look at polls, the majority of pro-life, especially in a case where a woman's life is in danger, would say, yes, absolutely, get an abortion. And the vast majority of society feels the same way with regard to rape victims, etc. Or if the fetus is going to come out with a death sentence or a huge deformity that will lead to a painful death, and etc. When it comes to serious health issues of the fetus, serious health risks with regard to the mother, or cases of rape, etc. The vast majority of the society is in agreement with that. And let's take this further. All of those cases combined that people automatically bring up after shutting out half of the people from the conversation make up less than 8% of all abortions. Let's go into the numbers. First, abortions used to be a lot higher through the 90s. Like, for example, in 1996, the average amount of the annual amount of abortions around that time was circling around in the mid-90s, 1.3 million, 1.2 million. In 2019, the amount of abortions was approximately 629,000. 629,000 abortions were carried out, according to the CDC, in 2019. The vast majority of those abortions were done by women in their 20s. Over 90% of those abortions were done within the first 13 weeks of pregnancy. With regard to the reasons for abortions, 92.5% of all abortions are cited as being done for either social or economic reasons. So that's what the conversation is mostly about, because that's where you have over 92% of the abortions taking place over. So yes, you can bring up rape and all of this horrible things, but you're only bringing up something that A, doesn't account for the vast majority of abortions, and B, something which basically almost everybody's in agreement on anyway. So a true fruitful conversation is to really take place where, let's say you have a woman, this is the 92.5% of the cases, let's say you have a woman, there are no health issues or risks that are known, and there are no health issues or risks with regard to the fetus. It's not a case of rape, but it's a case of consensual sex. What does society feel about that here? So this is 92.5% of the cases. According to an AP poll, it was an AP NORC poll taken just last year, 80%, here, let me make room over here. 80% of all of the participants, the poll was give or take 4% error. It was over 1,100 adults. The poll, over 80% said that abortions, in this case where there are no health issues or risks and it's not rape, abortions should be illegal. Illegal in the case where you don't have rape, you don't have health issues, the mother is not at risk, for a socioeconomic reason, which accounts for 92.5% of all abortions. 80% plus, really, it was about 81, 82 if I remember correctly, but at least 80% think that it should be illegal, okay? Now, within the first trimester, over 60% of the entire society should be legal. Now, just to give a frame of reference as to how our laws compare to laws in, for example, in European countries, etc. New York allows for abortion up to 24 weeks. Same with Illinois. Virginia actually passed a law allowing it up to 25 weeks. Virginia, 25. France and Spain allows abortion in these cases up to 14 weeks. So we're actually more liberal with that choice in the United States in some of these states. A lot of states don't have the laws quite enumerated, or they may be outdated. These are states that recently passed laws. putting forth allowances for abortion. I don't expect anything to be federally done, as you have quite a divide there. But this was just to give a frame of reference. But you have, within the first trimester, most think it should be legal. Within the third trimester, the vast majority, 80%, including most pro-choicers, think it should be illegal. Well, again, if a typical pro-choicer thinks that it should be illegal in the third trimester, then that typical pro-choicer would not agree with the my body, my choice, because the fetus is just as much inside a woman in the third trimester as in the first trimester. So if it's my body, my choice, then every single one of the pro-choicers would follow that logic and say it should be legal. Doesn't matter if you're in your 9th month. But they don't say that, because as a society, we all grapple with the question of, in this case where nobody's life is endangered, you don't have rape, etc., how developed is the fetus? When does life begin? At what point would we be causing pain? At what point would we be violating a fundamental, inalienable right of the fetus? Could the fetus come out and survive? Would the fetus feel pain? Would it be inhumane for just this, for us to choose to be able to do an abortion at any time at that fetus? So society is grappling with the question, and it's clear in the polling that no matter what side you're on, that's the question we're grappling with. From Roe versus Wade until now, how developed is the fetus? And I think that that's a conversation that everybody can and should have. I respect anybody on any side. Make your argument, put forth your reasoning, and have a conversation. Talk in the public square. Be respectful of others. But as part of that respect, I think we should also be welcoming to all. I think we should welcome men, and I think we should welcome everybody. Men and women, everybody should be able to sit and have this conversation. And as a society, we could then, once informed, we can elect the representatives we want to elect. And those representatives can speak for us, and those representatives can enact in law what it is that most of us want. Please feel free to put any comments below, and I'd be happy to answer them. And I will be doing a lot more of these videos to discuss various topics. If you have a topic idea that you'd like me to discuss, please feel free to, of course, let me know in the comments. Send me a message. Like and subscribe. And I want to grow from you, and I hope that you're growing from me. So if you like this, if you took anything from this, please like and subscribe the video. I look forward to having another conversation. Take care. This is Steve Rose. Take care from Lawyer Lens. Bye-bye.